Hello and good morning. Hopefully everybody can hear me online. My name's Jade Christie. I'm the SME Innovation Manager for Connected Places Catapult. Just like to welcome you to our masterclass today. You should have signed up for the Intellectual Property in Transport, Logistics and the Built Environment Masterclass. If it's the wrong masterclass, you'll still be getting quite a lot of information. So please do stay on. Just like to run through a few housekeeping while you actually are on. Please do keep your cameras off if possible, just so it's smooth in terms of moving through the presentation. We also have a Q&A function, but any Q&A questions you have during the presentation, please do put them in the chat and we will meet it at the end as per the agenda. So great to have you here once again. Thank you for registering. Without further ado, I'm now going to pass over to our esteemed colleagues from and IP attorneys, Guy and Conrad, to take you through today's presentation. Thank you.
Thank you very much, Jade, and thank you very much for the rest of the team here at Connected Places Catapult for all the work that you've done in the background putting this event together. I can hear people are still appearing in the chat as we go, and I'm sure you'll catch up and keep up. My name's Guy Edwards. I am a patent attorney at Gill Jennings and Every. We are an intellectual property firm based in London and Munich. We work with companies throughout the UK and across the world. With me today is my colleague Conrad. And as patent and trademark attorneys, we are specialized lawyers that help businesses protect their inventions and brands, turning ideas into legal rights and using those rights to support their commercial goals. A little bit about me. Before I was a patent attorney, my background was in civil and mechanical engineering. I then worked for the Ministry of Defence as a naval architect, helping design ships and submarines. And since becoming a patent attorney nearly 10 years ago, I've worked with companies of all shapes and sizes across the IT and engineering field, but I have a particular focus on marine technology, transport, manufacturing. Similarly, Conrad, I know, trained as a mechanical engineer at Imperial before he joined GJE's IT and engineering team. And equally, his credentials in this field are impeccable, because I know that in his free time, he is providing some of the mathematical and engineering muscle on a potential attempt to break the water speed record, which seems crazy to me. And so together, I hope you'll agree that we have a wealth of experience in this field and in IP more generally. And we're really well placed to help demystify intellectual property and give you some really clear takeaways that you can use to help your businesses and help improve your day-to-day running. And so what are we going to be talking about today? Well, first, Conrad is going to open with some basics on intellectual property and IP rights. Then I'm going to discuss IP strategy, hopefully provide you with some tips and advice for handling your IT and avoiding common pitfalls. And we're going to close with a discussion on some of the support that's available out there for innovative companies in the UK. And this is often support that we're not using enough. And we should have time at the end for some questions, as Jade said. I think you can just put them in the chat or hold them to the end, and we can handle them then. And with that, I will hand you across to Conrad to give you this introduction to what intellectual property is and what are IP rights.
Thank you, Guy, and thank you everyone for taking the time to attend today. I'm sure that many of you will have some knowledge of intellectual property, which will often in this talk just shorten to IP. Having said this, IP is quite complicated, and even technology correspondents in the media often get it wrong. So this is a bit of a brief overview to help clarify some of the fundamentals. So next slide, thank you. So what is intellectual property? Well, broadly speaking, property is something you can own, and the value of a business comes from its property and assets. It is easy to value and protect physical assets. We can see them, we can hold them, and we can usually store them securely. These will all be things that we'll sort of know and recognize in our day-to-day lives. However, intellectual property is often a bit more difficult. It's intangible. So it's difficult to determine the value and often difficult to protect it in itself. In order to help this, governments provide an internationally recognized set of IP rights to help set up IP rights to help people and businesses protect their ideas. Next slide, please. So, there are a large number of different IP rights. The table here shows the most common types of IP rights and what they protect. You'll probably have heard of many of these, if not all of them, and they can also overlap with one another. Broadly speaking, innovations, such sort of inventions, R&D, can be protected via patents. Branding and brands can be protected via trademarks. A product's design and overall appearance can be protected with design rights, and content and artistic creations can be protected by copyright. You've probably noticed these 4 examples in your day-to-day lives and are likely what you think of when someone says intellectual property. However, the final item on the list, a trade secret, is a little different and often overlooked. A trade secret is private knowledge that only you and those in your business are aware of. Think of the Coca-Cola recipe or the KFC blend of herb and spices. The secrecy is valuable, but you have to be very careful. A third party can develop the knowledge independently or reverse engineer it from your product. Next slide, please. So, I don't know about you, but as always in this 4-year cycle, I was glued to the Olympics this summer. So I thought as an easy example to work through some forms of IP, we could have a look at the super shoes that we saw the marathon runners use at the games. Specifically, these super shoes are a new generation of trainers which are super light, have a huge amount of foam, and comprise a springy carbon fiber plate which helps runners push off the ground. As I'm sure you have noticed while watching the Olympics, they all seem to be made in pretty extreme colors. So let's have a think about IP rights that will likely exist in these trainers. Next slide, please. So, examples of IP that may exist could be a new formulation of the foam in the soles, or a new carbon fiber plate to provide a spring to athlete's step. Because these are new technologies, often coming via R&D, they would likely be protected by a patent. The Nike swoosh, or even the Nike name on the top you can see there, are aspects of branding, and they tell us as customers which company has made the shoes. I'm sure all of us, when looking at that picture, immediately recognize that it's a Nike shoe. Therefore, these elements of branding are protected by a trademark. Staying with these visual aspects, the overall outward appearance of the shoe would be protected by a registered design. This protects against direct imitation of the appearance of a product. Finally, it could be argued that the shoe itself is quite artistic, depending on your preferences. Nike have put a lot of effort into designing the colors and the ink blob print on it to make it distinctive and eye-catching. They didn't have to, they serve no technical purpose. Therefore, Nike could argue that certain aesthetic elements of the shoe are protected by copyright. Equally, the shoes will have been marketed extensively by Nike, and this marketing material, such as TV commercials and the music and dialogue within them, themselves will be protected by copyright. So, the same product, even just sort of a trainer as shown, can be protected by a combination of the overlapping IP rights, some of which you may not have considered as possible previously. However, while the same product can be protected using a series of different IP rights, it does not mean that all of them are equally important to every business. For those of you working in transport, logistics, and the built environment, protecting the aesthetics of your product is probably less important than protecting the underlying technology of your business. It is important to recognize the relative value of each intellectual property right to your business. This is especially true given that enforcing IP rights and even obtaining them in the first place will cost money. And therefore, it is important to consider your commercial aims when assessing which IP right is for you. Next slide, please. So, having discussed the main intellectual property rights, namely patents, trademarks, designs, and copyright, let's talk about some of the key features that are common to all of them. Firstly, They're all called so-called negative rights. This is something which can often be quite difficult to understand, but effectively, they allow you to stop other people from using your idea. They provide a monopoly and can prevent imitators or copycats. However, it's quite important to realize that it does not guarantee that you yourself can use it. So I'm sure you've all seen the headlines about Taylor Swift's record-breaking New World Tour. If I were to use some of the current hype to earn some side money by performing some covers of her music in the local pub, then I could stop someone selling a bootleg recording of my performance as I own the copyright to the performance. However, Taylor Swift, in turn, could stop me from performing her songs as she owns the copyright to the songs I covered, which would probably be a good thing for everyone. Secondly, whilst the specific requirements vary from right to right, in general, to register or obtain IP rights, the idea has to be new or novel or different from everything previously known to the public. As well as this, the idea usually has to provide some form of meaningful improvement over the ideas that have come before. Hopefully, both of these seem like fair requirements. The idea is you have to actually be inventive or original for you to receive some monopoly protection. Lastly, IP rights are jurisdictional, by which I mean that you cannot obtain a worldwide patent or a worldwide trademark. A UK patent protects your technology in the UK, but not in the US or France or China, for example, and vice versa. Therefore, it's very important to seek protection in each jurisdiction which is commercially relevant, and if cost is an issue, to prioritize which one is of most concern. Next slide, please. So, we've gone over some of the shared features. Here are some of the differences. Firstly, some rights exist automatically on creation, the main one being copyright. This means that as soon as an author writes a new text or a singer comes up with a new song, it is immediately protected via copyright. It does not need to be registered or applied for. However, with these, it often means that it's then on you to prove that someone else has copied it and that the right exists because it's not on a register somewhere. Secondly, other rights, such as patents, need to be applied for and therefore a form of registered IP. The application will have to be undertaken with a relevant government body. So in the UK, it's the IPO, the Intellectual Property Office, and you may have to employ an IP lawyer to assist you. Lastly, IP rights are all temporary and all have different lengths, most being in the range of a few years or a few decades, and with some of them, you may have to prove or pay a fee to show that you are still using the IP that it protects. However, there is one interesting, quite heartwarming exception. The copyright royalties behind Peter Pan is indefinite, as the British government in the 1980s decided to change the law such that it allowed Great Ormond Street Hospital, which was gifted the copyright by the author J.M. Barrie, to have an indefinite right to the royalties in the UK to support it as a charity. This is quite interesting, as the government fundamentally changed the legislation to allow this. And on that positive note, I will now pass you back to Guy to talk about how you can use these IP rights. I think you're muted, Guy.
Thanks, Conrad. Thanks for the tip about being muted as well. Heartwarming story about Gosh, isn't it? That's what I was saying. So, having had that introduction by Conrad about what intellectual property is and what IP rights are out there, the question is, why do you need them and how can we maximize them? And it's worth recognizing that even if you currently aren't using IP, your competitors are. In 2022, which is the most recent set of statistics, there were over 8,000 patent applications in the field of transport filed at the EPO, just in 2022 alone. Similarly, there were over 4,000 civil engineering patent applications. And so it's clear that this is an increasingly congested field from the perspective of IP, and it's important for businesses to make sure that you're not being left behind and not being cut off. I thought I'd start with a series of pithy quotes that I'd come across in my time working in the industry. Each of them having a slightly different way of viewing IP. So firstly, one of the early things I read was that IP provides a sustainable competitive advantage. And it's worth appreciating that without IP, intellectual property, there isn't differentiation between companies. There isn't differentiation between products. If your companies don't have intellectual property, don't have a difference in appearance or the features of it, you're making the same product. You can only compete on price. Your product quickly becomes a commodity, and perhaps a company can cut costs or reduce its margin, but that isn't really a sustainable way of doing business because someone else is always going to try and undercut you. Instead, seeking IP rights or making sure you're leveraging intellectual property helps make sure that you've got a sustainable difference between you and your competitors, that your product is truly better than what they're offering, that you've got a better reputation, that your branding on your website really attracts new customers. And those are more, they provide you a really sustainable way of improving your business. The second point there, I appreciate, is a bit mercenary. Whoever owns the IP owns the profit. But it is true that the person who has the rights can market the business themselves. Having said that, it's a bit more impressive in principle than reality, because owning IP is not a guarantee that you can make a profit. There's no point filing a patent application if you can't sell the product that uses it. The third point, IP rights are a sword and a shield. I heard this from a head of IP a few months ago, one of our clients, and that was the language he used with his board to convince them that the investment was worthwhile. Intellectual property is a sword that can scare off competitors and maintain your territory. It's also a shield protecting you from other parties who might try and muscle you out. And from all those three in advance, the first three, I think the final one becomes clear that IP is an invisible edge for many companies. I think that comment really speaks for itself. So, as Conrad said, IP rights allow you to protect your ideas and protect against third parties copying or imitating them. An IP strategy is a formal plan for how you exploit these tools and maximize their benefits. And what are these benefits? So it's important to recognize, I've put 5 up there. I think these are some of the most common, and it's important to see that they are all commercial benefits, not legal ones. It's easy to think, oh, with a patent, I could sue someone for patent infringement. But in reality, very, very few IP rights are ever litigated in courts. Sticking with patents, because that's my background, you see in UK courts about 50 patent infringement and validity court cases each year. In contrast, you see nearly 20,000 UK patent applications and nearly 200,000 European patent applications filed each year. So the fraction of 1% of all the patent applications that are ever filed are litigated. So instead, the benefits of IP rights are soft benefits. They're the persuasive aspect they have, the threat of legal action, the symbol that you're an innovative, forward-looking business. The value is in how they can improve your commercial position rather than your legal one. And in parallel, as I mentioned on the previous slide, obtaining IP rights on their own is not a productive goal. The goal of them should be to support your business. Now, when I give this sort of talk to larger companies, the most important benefits they see are the first 2 on that list in front of you. They're very keen to increase their market share, to turn their intangible ideas into money-making assets. They need to turn a profit. They're really pushing for profit. The third point is applicable to all types of companies. A good IP strategy is going to consider and manage the risks of third-party rights that could stop you. And for small companies, maybe this is just being aware of what who your competitors are, looking at their website periodically, seeing whether they're launching any new products. Whereas for larger and larger companies, you might see more investment into time investigating what prior art exists out there, what IP rights other companies have, to make sure that you're proactively avoiding being caught in a trap of patent infringement or stepping on the toes of somebody else's trademark. For startups and small businesses, finally, the final two comments are more and more important. Appealing to investors is key for many SMEs, and I'm sure lots of you listening today will feel that an IP can be a really strong tool in attracting investment and improving your valuation. And then finally, I think that final point is particularly important to all of, or maybe particularly important to those of you listening today. Transport, logistics, the urban infrastructure, it lends itself to collaboration. You're often working in a larger network with a lot of stakeholders in your environment. An IP can be a really powerful tool in bringing those people to the table, to push them to work with you, to not sidestep you and take a different route. And so, in summary, I think there's a huge range of benefits of IP that go simply beyond their legal concept of the rights behind them. And so that's what I think is the benefits of IP rights and strong IP strategy. What is good IP strategy? Again, I've thrown some thoughts up here. To my mind, it's, as I've already said, it's not simply about filing patent applications and trademark registrations for the sake of it. It needs to support the underlying business. It's equally not about ignoring the risks by third-party rights and just hoping that nothing will happen about them. It really pays to be proactive and make sure you're not wasting investment when you're setting up new products, when you're setting up new projects. A good strategy is going to make intelligent use of the whole IP framework. Conrad said a moment ago that the best IP rights for your business are going to depend on what your company is and how your products work, and that is totally true. A good IP strategy is also going to be ongoing and regularly reviewed. Best practice I see is for companies to have a steering committee, an IP steering committee that meets quarterly to make sure that the investment that they are making in their intellectual property is correct, making sure that they're continually capturing their IP and protecting it where needed. Having said that, there is no one-size-fits-all approach. Any IP strategy is going to need to factor in your business, your competitors, the existing landscape of the sector you're in. But I think those are all points that you can see on the screen, are all points that you can use to think about where intellectual property sits in your business and whether you can be using your intellectual property better. So, having given you an introduction or a start on what IP strategy is, as I said at the beginning, here are some thoughts on how to avoid some common IP mistakes. What are the pitfalls that we should be avoiding? So these are common to almost all businesses. The top one is really powerful and really important, is that you should be considering IP protection before you launch your products. As Conrad said, to get IP rights, your ideas have to be new, novel, sufficiently different to everything that's come before. And that includes the disclosures that you as a company have made. And we've had people who've not realized come into the office and say, I want to file a patent application on my new widget. And you say, great, who knows about it? And they say, oh, well, I published it on my website last week. And it's heartbreaking because that breaks the possibility of obtaining a patent. because your patent has to be new, it has to be inventive over everything that the public has seen before. So as a company, you've got to be thinking about, are my ducks in a row before I launch a product? And in turn, that leads on to the second point. If you're naturally, when you're developing a product, you've got to share information, you've got to seek a manufacturer, you've got to make sure that a customer base exists, and confidentiality agreements and NDAs are the way to, or the safest way to do that. My top tip on that is you can find some really good pro forma non-disclosure agreements on the UK government website. So if you're thinking that, oh, I'm going to meet an investor or a potential collaborator, I'd really recommend you look at them. I think there's 6 or 7 that cover slightly different interactions, whether it be you speaking to a university or you're a university and you're looking to seek funding. And so if you type in UK Intellectual Property Office non-disclosure agreement into Google, you'll have that pop up. So yeah, UK Intellectual Property Office non-disclosure agreement, it'll just pop up. Continuing down the line, it sounds like I'm tooting our own horn here, but it's hard to stress enough that seeking professional advice is key. So you can file a patent application on your own, and individuals do, but the stats show that really doesn't lead to success. Only 1 in 20 patent applications that are filed by applicants without representation by an IP attorney ever get granted. So that's less than 5% chance of you getting a patent granted if you file it yourself. And that's not because the idea is bad, it's because there are a set of quite stringent rules that a representative an attorney can help guide you through. In contrast, for representing companies, the chance of success is well over 2/3. And in fact, that number is a little soft because the UK Patent Office is used for filing to get stuff on file early, and then a common strategy is to withdraw them. So in total, seek professional advice is the key here, whether it be with us or a different company in the field. If you're looking for IP help, seek professional advice. And then the final 3 points, don't simply file and forget. You should be monitoring your applications, monitoring your patents, your trademarks, your design rights, because they have costs through their lives, and it's important to make sure you're getting true value for money throughout them. And I'm going to talk about collaboration and international trade on the next couple of slides, but because they're really important for people in this field. So collaboration agreements, as I say on the top there, infrastructure and logistics tends to lead to collaboration. Projects are large, long-term, there's a lot of stakeholders. With that in mind, it wouldn't surprise me if many of you are going to consider entering into a collaboration agreement at some point. And I'm not a contract lawyer. My specialism is not quite that dry. But I've put up some bullet points there on what I'd expect you to see in your agreement, worth saying that all of them are negotiable. These are sort of commercially agreeable terms that you could work out with the other side. But yes, I'd expect to see details of the ownership of the IP before the collaboration, who's bringing what to the table, and to ensure that you have access to the IP during the collaboration process. I'd expect there to be details on who owns the IP produced during the agreement. So is a new invention that's come up with during the collaboration owned by both of you together? Is it owned by one company or the other? Do you set up a holding company that will own the IP that you both have access to down the line? And it's really useful to spell all that out up front. And then equally, it's important to work out who has access to the intellectual property afterwards. Is it just a project that's developing for one of you, a sort of where you're going out, getting a person to do some research for you, but you're then going to expect to use it yourself down the line and you don't want them to have any rights? Or is it truly a collaboration where both parties are hoping to use the ideas afterwards? And then the final point, as I've already mentioned on the previous slide, that confidentiality is often key, and I'd expect a collaboration agreement often to have some form of clauses on what information can be shared publicly. And then this is really important. I wouldn't give this slide for if I was doing this in a different sector, but there are, for those of you in transport and logistics, the IP impacts on international trade are really important. The first point here is an interesting one. IP rights can't be enforced on foreign vehicles and vessels that are only temporarily visiting a country. What does that mean? It means that if you have patent rights for I don't know, for almost anything, for maybe a TV on a cruise ship, and the cruise ship comes into port in the UK, but is flagged in the Marshall Islands, but which is registered offshore, and it comes into the UK waters, but it's using your TV, you unfortunately can't sue them for patent infringement. You can't stop them, and that is really important for us when dealing with companies such as yours in these fields. And we have to be very careful on where we are filing patent applications, because in that case we can't protection in the market where the product is being used, the ship or the train or the lorry is going in and out of doesn't work. We have to look to the country of manufacture or the home country of these vehicles, and it could be an interesting decision on where we seek patent protection or where you seek trademark protection or design rights based on your business. And so I guess the final point of the slide there is important, is that laws in different countries are important, and a professional can help guide you through these decisions. Equally, if you are interested in filing a patent application, an attorney will help guide you on where you can be able to file the application. First, you can get worldwide protection through different applications in different countries, but there can be restrictions on where you go first. So, having talked about what IP is, what IP strategy is, some tips and tricks to avoid tying yourselves up in knots, we thought we'd finish with some information on what support is available for you out there. The first one is, well, firstly, congratulations on finding Catapult. Catapult and Innovate UK are two government bodies that produce a lot of supports for innovative businesses in the UK, especially SMEs. They run funding competitions and forums and symposiums, and they're all super useful stuff. I'd really recommend it, if you've somehow stumbled on this talk without knowing about it, to check them out. And I'm sure you can get in touch with Jade or the rest of the CPC team here, and they'll be happy to help. Then I'm sorry to talk about tax. I'm not a tax attorney, but I'll be as quick and clear as I can. There are two huge opportunities for innovative businesses in the UK, one of which is the research and development tax credit, one of which is the patent box system, and both of them give you a huge tax reduction depending on what you're doing with your business. The first one that's shown on the screen there is the R&D tax credit. You might have heard about this recently if you're a Formula One fan. A couple of years ago, Red Bull, one of the Formula One teams, they fell foul of the cost cap rules because they spent too much money. But actually, they only spent too much money because they managed to screw up their application for this R&D tax credit, or that was one of the reasons they gave. And so instead, all the other teams got like, I think it was like millions of pounds in tax rebate back, but Red Bull missed it, and they then got a series of penalties because they'd gone over their budget. And so if it's good enough for, I guess the top level from there is, if it's good enough for Formula One teams, it's good enough for your business. The rules are a little complicated, and it may be something that would be good to talk with your financial advisors or your finance team. But for SMEs, you can deduct more than you spend for your tax liability, For larger companies, you can get a credit of 13% of your R&D costs. Importantly, you can backdate it. So if you haven't been doing it so far, go and find out if you can get the rebate now. And equally, you can surrender your losses for future years. So you're investing in R&D now, but you haven't made a profit yet. You can save tax on the profit down the line. And it's worth saying, we're not in the transport and infrastructure industries. We're not good at applying for this. This is a graph. Hopefully you can see it, because I know the writing's a bit small. This is a graph from HMRC showing which industry sectors are claiming the most of this R&D tax credit. And you can see from the big bars that manufacturing, sciences, IT, they're all writing off 1.5 billion each. But then if you look at this tiny line here, which is H, transport and storage, we're not doing a good job. Similarly, public administration, defence, social services, almost no claims being made at all. If finance and insurance are making nearly 500 million pounds of tax relief, surely we can do it. How much research is there really going on in the in the insurance industry? So this tax credit's out there. If you're not using it, go find it. Similarly, there's a patent box tax credit, which basically gives you a reduction in your corporation tax based on your profits if you have a patent that covers your products. And that can be really powerful at making your patent portfolio pay for itself. In fact, we have plenty of clients who deliberately seek UK patent protection for this reason alone. They don't actually care about stopping their competitors using the technology. They might not be able to get strong enough patent protection to really cut out the market. But what they can do is get a really focused, narrow patent that matches onto their product perfectly, and then gives them this tax rebate. So, as I already said, if you're not already making use of these tax credits, speak to your finance team or your financial advisors. I know there are consultants out there that help businesses with both of these as well, if you're a smaller company and you're looking for some help. And finally, on talking about support, we've talked about one example of support for about 40 minutes now, and I promise I'll stop in a second. IP rights are a government scheme to help innovative businesses. The whole point of patents and trademarks and design rights and copyrights is that the government are giving you a monopoly on your ideas to encourage you to innovate, to develop new things, to improve society. And that's the core of the IP system. It's a quid pro quo. Companies get IP rights, consumers get better stuff. And that really returns us to the point that we've said a couple of times through the talk. The IP system's government support for business, and are you using it correctly? Can you use it better? If you don't, your competitors might. And so finally, a small plug for us. How can we at GJA support your business? There are plenty of patent attorneys out there and trademark attorneys out there, and we all do good stuff. Here at GJA, we're offering a series of free IP clinics to the first 10 CPC network members who get in touch after this talk for a sort of 30-minute telephone call just to triage your issues and talk about what IP you have, what you might think of as some next steps, whether there's anything obvious we can do to improve your position. If that's something you're interested in, you'd like a free 30-minute call with one of us, either me or one of my colleagues, then please get in touch. My details are on on this slide here. And with that, I'd say thank you all for listening. I know there are going to be some questions, and I'll leave it to Jade and Megan at CPC to moderate that section.
Thank you very much, Guy and Conrad, for that was a very good presentation. This is quite interesting. The world of intellectual property. It's massive, with loads of different intricacies. That's perfectly fine. As Guy mentioned, we will also be circulating their information. So if you did want to look at some further support, we could definitely get you in touch. So now's the Q&A section of our presentation. So please do fill the chat with any questions you have. I see that we have currently 3 questions in the chat currently that we'll run through, but we do have some time. So please, if you've got any issues, questions, queries, or maybe something a little bit out of the ordinary in terms of intellectual property, we'll try our best to address those today. So first question, which is usually the $1 million question in all our presentations, can we have access to the slides? Is that okay to circulate those slides?
Of course, I think the easiest thing would be for you at CPC to send them out afterwards, if that's all right.
Yeah, perfect. Second question, what about disclosure of IP before it is protected? Are NDAs, etc., sufficient? And can disclosures be retrospectively protected in any way?
Yeah, so hopefully I've covered that in the talk. We'd recommend the gold standard is a written non-disclosure agreement or confidentiality agreements. There are, as Conrad said, if you're dealing with copyright and with design rights, some rights do exist automatically when you create the ideas and first write them down, but it's a bit of a risky situation to be in. On the other hand, patents especially, you have to be different over everything that's become available to the public before, and that's both what other people have said and what you have said. And so you really need to be filing first and to be working under confidentiality agreements before you file your patent application.
I think there are potentially 2 things to add. One is sort of a bit more of a hopeful note. In the UK generally, they can be hopefully quite common sense that if the person you're working with should have kept it secret, then often they can be a bit more sort of lenient. And secondly, it might sound like a bit of a silly and obvious point. However, we have had issues with clients in the past. If you do have NDAs and other similar agreements between parties, make sure it's signed by everyone, and also make sure that you keep a safe record of it so it doesn't go missing a few years later when you actually need to use it.
Perfect, thank you. Moving on to our next question, can you give an example where IP has been successfully applied in the real estate space?
Yeah, of course. Well, I think if you're thinking about IP, I'd say I live in London. I noticed the Foxtons minis driving all around the town. That's all covered in the Foxtons branding. They'll have trademarks to their green, and yet they're an estate agent if you're outside London, and one of the worst. Sorry if you work for them. But they're obviously very protective of their green and yellow branding, and in fact all the estate agents are. The colors of their signs are really important, and so they will often have UK trademarks on what their logos are, what their signs are, what shows up. Equally, I'm sure if you go, it's not quite the real estate space, but obviously builders and building techniques can be patented. If you walk into your B&Q or your builder's merchant and pick up a tool off the shelf, it wouldn't surprise me if the back said patent pending or covered by a patent. And so yes, I think you'd hopefully, well, or what tends to happen is you go to this talk, you learn a bit more about IP, and you start recognizing the copyright symbol and the registered trademark symbol a little bit more, and find it's actually more enmeshed with your life than you'd think.
Perfect. Next question. Can you talk a little bit more about the patent box tax relief, please?
Of course. Everyone's going, yay, more tax. So you pay corporation tax on your profits that your business has. And you're going to pay tax on both sales to customers and any licensing fees you make. So if you have a patent and you say, oh, I'm not going to make it myself, another party's going to make it and they're going to pay me a royalty, you have to pay tax on that royalty too. And it's either 25 or 19%, but it's cut. It can be cut to 10% if you have a patent on that product. So if you can say, I have in the past filed for patent protection for my TV, and I'm then selling the TV, I pay less tax on my profit from it. And as it says on the screen, it could be backdated for 2 years. Having said that, I'm not a tax advisor, but again, plenty of our customers or clients rather are use it and seek patent protection specifically to use it. And so if you have a patent portfolio and you're not using it, you should be asking, why am I not using it? You should be checking and see if you can use it in future. Hopefully that makes sense. Feel free to ask a bit more in the chat if you want a bit more, or perhaps send me an email with the details on screen now, and we can have a quick chat in chat over the phone.
Yep, just one more in the chat function before we move to the Q&A section. So just linking back to the previous question in regards to the NDA and disclosure of IP. I think it was more targeted towards unregistered design rights in Europe, which can in some cases be subsequently registered within a certain time frame.
Yeah, absolutely. So I mentioned sort of briefly, this is the nature of the time involved. There are both unregistered design rights that exist automatically, and you can also get registered ones where you file at the UK Patent Office to put it on file. And the registered version is much more powerful. It is longer standing. It gives you more rights. And so if you have a product that really its appearance really matters, like the running shoe, like I don't know, like Trunky, the kids rolling suitcase is a good example when they went to court for on their designs a few years ago. We'd recommend you use a registered design, and you are right that you can disclose the product, its appearance, and then subsequently file, but that file for that protection, but that is limited to 6 months of that grace period. And also that in that 6 months, when your product is out in the field, out in the market, you're not protected. A third party can come along and copy it or develop their own version, and you will struggle to stop them, because whilst you're still in that period covered by unregistered rights, they're not as strong, and so there is risk there, which is why I would say file as early as possible. The design application process is super quick. You just need the drawings of what it looks like, and you can get it on file in a couple of days. There's no big drafting process. So if you can file early, I say do so. The flip side of that, of course, is there is a cost involved. Maybe you'd like to put it on the market for a little bit, see what the market feels like before going forward. But there's a risk management that we or another attorney could talk you through.
Perfect. Thank you very much. Just a hand over to my colleague Megan to see what we have in the Q&A section.
Yes, perfect. Thank you, Jade. So we have a question here saying, in terms of IP and construction projects, if, for example, a port is building a new berth and introduces initiative design or sustainable construction process, should the port authority file for IP as they are paying, or the construction company, or both file?
Interesting. I think then it would depend on who has come up with the idea, who has developed the idea, and they're the true initial owners. So if the construction company has developed a better way of putting the port together, then that's their idea. They could get patent rights. They could take it to a different port authority down the line, and reuse it. On the other hand, if the port authority that had come up with it and they'd specified it when they went out to tender, the rights would stick with the port authority. But in reality, I appreciate that often these ideas are created through collaboration, and that's why the sort of collaboration agreements that I'm talking about earlier on are important to show how the IP flows through the project. Hopefully that's a good answer. In reality, if it's not obvious which of you has done it, there'll be some negotiation on how you handle it and who also pays for the application to begin with.
Thank you. I have another question here saying, do we need to have the prototype of the innovative product ready in order to get the patent granted?
That's a really good question. The answer is no. You don't have to have a product in place to file for a patent application. Equally, you don't have to have a product made to file for a design registration. However, there is a requirement. We talked about that the ideas have to be new and different. There's also a requirement that the technology actually has to work, and you have to describe it sufficiently. The idea being that patents have a limited timeline of 20 years. You have to tell everyone how you do it. In return, you get patent protection for 20 years, but at the end, everyone can use the technology. Your monopoly is time barred. And so that's a sort of quid pro quo from the government again, that you get protection, but you have to tell everyone how you do it, so society improves. And so while no, you don't have to have a prototype working to get a patent granted, and in fact, plenty of our clients will file patent applications early in the design process before they've finalized a product. It does actually have to work. You can't just speculatively file an application for a perpetual motion machine and get a patent for it, because it just won't work and you won't be granted a patent.
I think another thing to note is that often the patent will be filed very early on in the R&D process, and therefore there's a good chance that it will be filed at sort of the initial idea stage where there hasn't been time to have the prototype yet. And so the prototypes will come along at the same time as the application is being sort of prosecuted through the government. So yeah, I'd say it's quite common, especially in this sort of market, for there not to be a concrete prototype to exist before the patent is filed.
And in fact, it's one of our common steps is we work with clients as they often, as you develop your prototype, you come up with new extra small ideas, and folding them into the existing application family is an important step that we take with our clients during the patenting process.
Yeah, and also having a physical prototype can occasionally make it more difficult to keep it undisclosed and sort of secret. So that can be another reason why getting a patent filed before you start having these, physical prototypes and start testing them might be a good idea.
So we have two here that are about more about software. So I will put them both together saying, so do you have any specific challenges to applying for software IP as opposed to physical inventions? And is getting IP granted for the software more difficult than physical assets?
Yes, and this is like a common question we get at these sorts of talks. It is possible to get patents on software. Companies like Apple and Samsung and Huawei are all doing it. However, you run into a series of restrictions on what is truly an invention, and governments in their wisdom have said things like you can only get a patent if it's an actual technology, not if it's a business method, not if it's just a different way of presenting information that already exists. Those are not seen as technical inventions worthy of a patent. And that's quite now we're in an age of software. Those are quite archaic rules and restrictions, but it means that we as patent attorneys have to work hard to uncover what it is that's technically happening with your software to get patent protection. We need to be looking at, are you making the computer run more efficiently? Are you making an impact on a process that happens outside of the computer? And those are the sorts of questions that a patent attorney can talk you through. That, so at top level, software can be protected. It just is a bit more difficult than in other fields where there's a physical product sometimes.
And just following on from that, somebody said, so any thoughts or experiences that you might be able to share, obviously with seeking IP for software, but then specifically for data analytics software where the source data is definitely not their own IP. Does that add more difficulty?
Where the source data is not our IP.
Yeah.
So the data itself wouldn't be protectable. How you're using it can be, but it would really depend on the specifics of the situation, on whether you are using that data in a technologically impressive way. Those are my words. Those aren't quite the words that the patent officer would use. But it's that, are you creating a technical impact with that data as you use it, or are you simply creating a new visualization, and are you reformatting it in a certain way? And so if you're just reformatting it, that may be really valuable to your clients, and it may be really may allow people down the line to make improved steps, but it's an indicator that that you might fall outside of the scope of patent protection, I'm afraid. But I think we'd need more specifics to be able to give you a clearer answer on the specifics of that.
As a bit of a coincidence, I'm actually about to hopefully publish an article today or tomorrow, pretty much exactly on this issue, about software using data analytics in the sort of marine transport space. So potentially once that's published, we can forward it on, and hopefully we'll answer some of the questions and ideas behind this in a bit more detail, and you can have a look at it in your own time.
So keep an eye on your LinkedIn. Is that the best way to do?
Perfect. And then I actually have one final question, if that's all right. So in terms of maritime logistics, where there are low barriers of entry, but has international regulatory enforcement, can or does an IP strategy creep into market fixing territory? And then they go on saying, for example, if a classification society offers new software to clients helping their lowering emission strategy on an EU shipping route and other shipping companies on the same EU route, could the EU deem that anti-competitive? If you've got all that.
Is the answer yes. So the question is, if you've come up with a patent that is standard for the industry, what happens? Because you can't lock everybody out of the industry. There needs to be some competition. And we call these sorts of patents standard essential patents. And they're quite common, especially in mobile telephones and telecommunications is the most common place we see them. And what basically happens is that they can fall foul of competition, but as a result, you give out licenses. And so Apple owns a huge number of patents on its phone, which it licenses out to anyone that wants it for a royalty. Similarly, so does the Huaweis and the Samsungs. And everyone then has access to the technology. There is no restriction on competition by being locked out of the technology, but instead everyone else's phones get a bit more expensive, and you can lower the price of your phone slightly because by the same amount by your royalty. And so that's an example of that sustainable competitive advantage I mentioned earlier on, that depending on whether you fall under the standard essential patents, you might be required to give a license out to people who would like to use it. But in reality, the actual number of fields in which that happens is actually quite low. And so I don't imagine that would actually be an impediment to you in reality. I'm sure there would be, almost certainly, there'd be some way of working around it in the way there isn't when you need to communicate with your 5G antenna in a very specific way, and there's no variation allowed.
Perfect. Thank you very much. I believe that's it for the questions for this session. Guy and Conrad, thank you very much for a very informative and interesting presentation. And I think that's reflected by the chat. There's loads of great sessions, and thank you for the informative session as well. Just want to encourage you. We will be sending out the slides, also Guy and Conrad's information. As they mentioned, you do have an opportunity if you're the first 10 to get a one-to-one telephone consultation.
Yes, yeah.
30 minutes or
you
so.
can do it on telephone or Teams
Yeah.
if that works for you. Yeah.
Perfect. So I would say definitely take up that offer, because there's a lot of information provided today, but maybe your questions might be a bit more detailed and unique, and you need to have that support. We will be forwarding around a feedback form as well, also how you can join the CPC SME network. So please do look for your emails and be the first 10 to get in touch as soon as possible. Once again, thank you for attending today, and we will see you in the next masterclass. Thank you, Conrad. Thank you, Guy.
Thanks, Jade. Thank you, everyone.
Thank you.
Thank you. Bye.